How can court determine if in the first place there was no hearing? You know, just the thought of it doesn't make any sense. By this court as it's sitting, receiving the particulars of the sureties in the record, that in itself amounts to hearing. Whether it determines the application or not is something else. And that is the integrity of this application that we seek to have maintained. The entire process of it. By hearing the sureties, getting their name, getting their residence, getting their phone number, getting their national ID details, that in itself is tainting the application in its entirety. And we want to arrest that abuse. And there is no doubt, once an illegality is brought to the attention of court, court must not close its eyes to it. My senior brother, the Honorable Sereko, said that I had said, and I wrote it verbatim, that I had said that this court has in the past adopted the practice in applications. I did not make that submissions, far from it. And there is no practice I brought to the attention of court that has been adopted before. Your Honor, there is a very big difference between a registrar appearing in a matter such as this and adjourning, then appearing in a matter as this and receiving particulars of sureties. When a registrar sits and adjourns a matter, the registrar is not hearing the matter. But when he goes ahead to entertain and get information that informs the determination of the application, that is a hearing of the matter. Which cannot be tolerated by this honorable court. A section was read, section 14(2)(c), and I would first want to read it verbatim and I make an explanation thereafter. So section 14(2) says, subject to the Constitution and this Act, the jurisdiction of the High Court shall be exercised A, in conformity with the written law, including any other law in force. Then when we jump to C, where no express law or rule is applicable in any matter, in issue before the High Court, in conformity with the principles of justice, equity, and good conscience. No express law or rule is applicable in a matter, in issue before the High Court. When the law says before the High Court, it is talking about before a judicial officer entertaining, lawfully authorized to entertain the matter. The High Court is not seated here. It's not. We cannot say these proceedings are proceedings of the High Court. They aren't, as far as this provision is concerned. So this refers to the High Court sitting. And it says that the principles of justice, equity, and good conscience. What does justice require? What does equity require? What does good conscience require in the instant case? What does it require? justice require? The man is rotting in prison, he needs to come out. But we are not going to illegitimize his application. He needs to come out. And I'm okay with him coming out, but in a proper way.
Concede to that, Your Honor.
So what does justice require? What does equity require? What does good conscience require? In a division like this, where there are other judicial officers, what is too hard with another judicial officer today hearing this matter, one authorized by law, today? That would be justice, that would be equity, that would be good conscience. What is too hard with that? Let Mwizera have his day before a judge and have his application determined. No, my lord, you know, counsel, you are not going to divert me. I am responding to section.
It shouldn't be restricted to what we stated before.
I'm responding to section 14(2)(c), and that is what was raised.
Your Worship, we need some order in this.
My brother, please do not distract me. For your record, I cannot be distracted. For your record. Most obliged. And I request my brother.
When he raises up,
so my brother, it's my day. What does the principles of justice require? What do the principles of equity require? What do the principles of good conscience require? Under the instant case, where even the registrar wants to receive particulars of sureties but cannot go further to hear anything further than that. What is justice? When we are going to adjourn the matter, then when a person who can entertain it comes and you see, think about it. Your Honor, it is my duty as a Minister of Justice to make sure that any illegality, whether it works on my behalf or against my behalf, it is my duty to make sure that it is arrested at the earliest opportune time. And I submit that, Your Honor, the best that this court right now can do is either adjourn this matter till a judicial officer that is authorized appears to handle, or Your Honor, seek supervisory